Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. Before we turn to the first case on our docket today, I want to extend a special welcome to our newest member of the Florida Supreme Court, Justice John Coryell. Justice Coryell, we are delighted that you are on the court. We're delighted to have you as a colleague. We're looking forward to the opportunity to working with you, and we appreciate your commitment to service on our court. And in the days to come, we'll have an opportunity to celebrate Justice Coryell's joining the court through a special ceremony. That's not been planned yet, but we look forward to that day. We can have a special celebration to mark your joining the court. Now we do turn to the first case on our docket, which is Ham versus Portfolio Recovery Associates. Counsel, please proceed.
Good morning. May it please the court. My name is Louis Rosenbloum, and I represent the petitioners Eugene Ham and Laura Foxhall. I believe I previously reserved 5 minutes for rebuttal. The issue in this case is whether Section 57.1057, the reciprocal attorney's fee statute, applies to an action brought under the theory of account stated. In this case, the actions were brought by a large consumer debt buyer against two holders of bank credit cards. And in the case, there was a contract between the bank who issued the original credit cards and the customers that contained a unilateral fee provision that provided for attorney's fees for collection actions only to the bank. Now, the first district in the Ham case, the case below, held that the statute did not apply to account stated causes of action, while in the Bushnell case, the conflict case, the second district reached the opposite conclusion. There are no disputed issues of fact. Neither side contends that the statute is unambiguous. So for that reason, with the court's indulgence, I would like to proceed with actually parsing the language of the statute. It's somewhat tedious, but I think in this case, it's very necessary. The statute is one sentence. It contains two clauses separated by a comma. The first clause is what the grammarians would call a subordinate clause, begins with the word if. And that, of course, immediately signals that it is about to establish a predicate. And the clause reads, if a contract contains a provision allowing attorney's fees to a party when he or she is required to take any action to enforce the contract. So stopping there, what this clause states is you look to the contract. You don't look to the cause of action that was actually filed. You look to the contract to see if it contains a provision allowing fees to enforce the contract. And in this case, of course, it did. There is a clause in the credit card agreement which allows for fees to the bank in collection actions. So once you satisfy that clause, you turn to the second or the main clause, and that's the one that says the court may allow a reasonable attorney's fees to the other party when that party prevails in any action with respect to the contract. The words "with respect to the contract" are, in our judgment, the key to the case. So the issue in this case is not whether the account stated causes of action were actions to enforce the contract, but whether they were actions with respect to the contract. Now, Portfolio has repeatedly argued that the key wording here is in the first clause, enforce the contract. But I would suggest that that would render the second clause meaningless, because you would never have an action to enforce the contract that wasn't also an action with respect to the contract. Now, there are several reasons why we contend that the account stated causes of action in this case are indeed actions with respect to the contract. First, just the language itself, with respect to, is much broader than breach of contract. With respect to could mean related to or associated with. Secondly, and I think more importantly, portfolio, the plaintiff in these cases, cannot prove the elements of the account stated cause of action without relying on the contract. And let me illustrate that point by highlighting a summary of the allegations that's actually in the Ham opinion at page 455. The first element of the cause of action pled by portfolio was that the debtor had business relations with the bank. Now, all of the cases going back probably 100 years in this state hold that for an account stated claim to go forward, you have to have a business relationship with the defendant. Well, the only way portfolio can prove they have a business relationship with the credit card holders is with the contract itself. That's what established the business relationship. The second element of the cause of action highlighted by the Ham court was that the debtors obtained and used credit cards to make purchases resulting in unpaid balances. Well, again, the only way that the debtors could use a credit card and incur balances is based on the language of the contracts.
Counsel, I'm sorry to interrupt you. Can I ask you a quick question? So if we believe that in context, the words with respect to the contract refer to an action to enforce the contract, under your theory, would you still be able to prevail in the sense, I mean, are you saying that essentially under these circumstances, this is an action to enforce the contract? Or does for you to prevail here, do we have to take a broader view of with respect to the contract than simply enforcing the contract?
I actually believe you would take a broader view. It is our position that the operative language is the with respect to the contract, which is indeed broader than the language enforce the contract. Remember, the language enforce the contract refers to the contract itself, not the nature of the cause of action. And so the third element highlighted by the pleadings is that the bank rendered billing statements to the debtors that were not objected to. Well, again, the only reason the bank would have to send these debtors a billing statement is because they had a contract where they agreed to pay for the unpaid balances. And then you have the billing statements themselves that were attached to the complaint by portfolio. And it's very interesting because they not only include the unpaid balances, they include late fees at $35 a piece, and they include interest charges, which in Mr. Ham's case was 29.99%, and in Ms. Foxhall's case, 26.99%. Now, these figures were not pulled out of thin air. They're right out of the contract. Mr. Ham's contract calls for 29.99% interest and a $35 late fee. And Ms. Foxhall rather, has a contract that has a variable interest rate and also a late fee.
Mr. Rosenbloum, was there also a claim for attorney's fees by the creditor?
There was not. And if I could address that, of course, they said, well, we wouldn't be entitled to them. I would suggest to the court that the strategy here that portfolio and other debt buyers have been employing is pretty obvious. They want to plead account stated as possibly a way to avoid paying prevailing party attorney's fees. And of course, if they ask for attorney's fees themselves, their strategy would fall apart. So that's not why they haven't done it. But what they have
Counsel, can I ask you a question though in that regard? When the first DCA says that had portfolio prevailed at the trial level, it would not have been entitled to fees under the credit contracts either. Was the first DCA wrong about that? I mean, I understand they didn't plead entitlement to fees, which under our case law means that they've waived it. But based on the contract language that you cite in your brief, it seems like it's broad enough that if they had wanted fees for this, they could have gotten it.
I believe they could have gotten, and I respectfully submit that the first DCA was incorrect when it made that statement. Again, but they would never have requested it. That would have ruined their strategy. And then that brings us to this court's decision in Caulfield versus Cantel, which the two district courts are in disagreement about. And in that case, we have what we've been calling the inextricably intertwined test. And in that case, this court interpreted an attorney's fee provision that used the language arising out of to decide whether the fee agreement covered a tort action for fraudulent misrepresentation. And in language that's been repeated in all the court cases around the state and in the briefs, this court said, had there been no contract, the ensuing misrepresentation would not have occurred. And therefore, the cause of action was inextricably intertwined. Well, that obviously fits our case. Had there been no credit card agreement, there would have been no billing statements issued. There would have been no account stated. And the Bushnell court, we believe, correctly said that the term arising out of, which this court used in Caulfield, is not materially different from the language with respect to, which is in our statute. And I would actually submit that the term with respect to is even broader than arising out of. The next argument I want to address is that portfolios—
Before you do that, Mr. Rosenbloum, excuse me, but I'd like to ask a question. Going back to the statutory language, the first part of 57-1057, the focus on action to enforce the contract, you seem to almost accept that that is referring to a contract or breach of contract cause of action, or a legal action, a cause of action to enforce the contract. Isn't the language broader than that? In other words, it says take any action to enforce the contract rather than file a contract cause of action. I'm not seeing how the word action there in context with the words that precede it, take any action, is limited to the legal cause of action. I think that's any action. What's your response to that?
Well, first of all, let me confess that my interpretation of this statute has evolved over time. And originally I said, well, the key language is enforce the contract. And we made the argument that what Justice Lawson, what you just said is that the account stated is broad enough to be considered an action to enforce the contract. And indeed, in the certified question that went up to the first DCA, which I confess that I drafted, it focuses on the language to enforce the contract. But Bushnell, taught me that I was wrong, that the operative language is with respect to contract. But I believe still that you don't have to have a straight breach of contract to satisfy the first clause. But if you look to the actual fee provisions in this case, they're very, very broad. It said basically, and I'm going to paraphrase, if we take any action to collect on your account, then we get attorney's fees. Well, collect on your account, there are numerous causes of action you could bring to do that, not just breach of contract. You have open account, and account stated, and so forth. So I would agree it does not have to be a pure breach of contract clause under the first clause of the statute. But please remember that it's the contract you're looking at in the first clause, not the cause of action itself. And the best way to illustrate that point is there's this case out of the 3rd District called Tylinski, which Bushnell distinguished and Ham relied on. And that's the case, if you will recall, where there was 2 contracts, one with a fee clause and one without a fee clause. And the defendant, prevailing party in that, argued that, well, the contract was, the cause of action was really related to the one that had the fee clause. But the action was brought by the plaintiff based on the one that did not have the fee clause. And here's the key, when the defendant requested the fees, the defendant requested fees from the contract that didn't have the fee provision. So call it a pleading mistake, if you will. But the point is that decision illustrates the fact that in the first clause, you're looking at the contract under which the prevailing party is claiming fees, not necessarily the contract related to the cause of action that's actually brought.
Counsel, how would we be furthering the purpose of the statute if we said that the reciprocity provision applied in a case like this one, where the plaintiff is explicitly not relying on the contract and not seeking fees?
Well, the purpose of the statute, one court said, is to level the playing field between parties that have a great deal of power and those that are unsophisticated and have no bargaining power. And certainly a decision so upholding Bushnell would further that goal. I think what Portfolio is, and one of their amicus has made this argument that ruling in our favor is going to create some kind of slippery slope. Well, there'll be much litigation about attorney's fees in every case. But I would just submit that if these debt buyers bring meritorious causes of action that they can prove in court with admissible evidence, they've got nothing to worry about. This case is a good example. Portfolio sued my clients, and they actually went to trial before the county court judge, and they couldn't prove their case. They brought a witness that did not have any admissible evidence, and for that reason, the county court entered judgment in favor of the defendant.
Mr. Rosenblum, you are now have consumed about half of your rebuttal time. You can keep going, but I just wanted to point that out to you.
I'd like to reserve my remainder of my time for rebuttal. Thank you very much.
Counsel?
Good morning, Chief Justice. Welcome, Justice Coriel, and may it please the court. My name is DIANE DEWOLF, and I represent the respondent, Portfolio Recovery Associates. Your Honors, if you'll permit me just a minute or two at the beginning here, I think it would be very important for this court to understand the elements of an account-stated cause of action. Your Honors, in our briefs, we've cited cases from this court and from all 5 district courts of appeal from 1914 up into the present cases of 2018. The cause of action for account stated is not antiquated, it's not obsolete, and it's certainly not novel. And from the cases that we've cited in our briefs, the following concepts apply. The action for account stated is based upon an agreement between the parties to pay an amount based upon an accounting. The account stated is not based upon any contract. A contract is not necessary to the cause of action. The account stated cause of action can apply if there's a contract between the parties or if there's not a contract between the parties. The original cause for the indebtedness need not be stated in the cause of action. The implied promise to pay, there's a prima facie case of account stated is found when there's the prior history of business relationships between the parties, when billing statements are rendered to one party and there's no objection made within a reasonable amount of time, there's a presumption that the account is correct and there's an implied promise to pay.
Okay, let me ask you this. Don't you have to show that there have been prior dealings between the parties? Now, for instance, a credit card company with whom I have no credit card, no relationship at all, couldn't send me a bill, a statement saying that I owed particular funds, and then be able to collect on that because I threw it away because this is not mine. I have no relationship with these people. You aren't suggesting that in circumstances like that the credit card company would be able to establish account stated without showing that there had been some pre-existing relationship, are you?
Absolutely not, Justice Kennedy, and that is one of the elements of account stated. There must be a showing that there was a prior business relationship between the parties.
But isn't the basis for that prior business relationship here the contract that established the credit card agreement?
Your Honor, the prior business relationship, what under an account stated is shown by the billing statements, and quite honestly, that's where this.
Well, the billing statement that I received in my hypothetical, where I have no relationship, it just comes in out of the blue. That's the billing statement that I received. That doesn't show any relationship. That just shows they sent me a billing statement. Well, so I'm not following your reasoning there.
Exactly, Your Honor. In this particular case, we have 12 months worth of billing statements that were all sent to the same address to the same party. The portfolio, when portfolio purchased the account, that notice was sent to the same address that all of the billing statements were sent to. The further communication by portfolio was also sent to the same address. And when service was necessary, the receipt from service of process all went to the same address. Now, the problem in this case, Your Honor, and there are other cases cited within the briefs where the prior business relationship has not been established, okay? And that is the McKissick case and the McKee case. And
it must be the case that something wasn't established here because you lost.
Exactly, Your Honor. You're exactly, Your Honor, and that's my point. So what happened here is the business records custodian was unable to satisfy the business records to the satisfaction of the court. So in this case, the prior business relationship wasn't established. And so what happened? Portfolio loses the case, but it doesn't turn the case into an action under the contract such that 57-105 would apply.
Let me ask you this, and this is something that puzzles me, and it may not be a decisive fact, and based on the arguments that have been presented, but I am just having trouble wrapping my mind around your assertion that the attorney's fee provisions in these two different cases that are before us did not allow, again, if you'd pled it properly, had not waived it, would not have allowed the creditor to collect attorney's fees. It seems that that's a very broad attorney's fee provision. The first one says, if we ask an attorney who is not our salaried employee to collect your account. And I don't understand any theory under which an action for account stated would not be covered by the scope of that attorney's fee provision. That mystifies me.
Justice Kennedy, there's two answers to that. One, and that's why I wanted to kind of give you the history of account stated, is the contract is not necessary to the interpretation or to proving an account stated. And this court said this back in 1914 in Whittington. In that case, the parties had a contract between them. The contract was under seal. We don't know everything the contract said, but we do know that it had certain provisions related to payment and delivery. Dates of payments and delivery. The plaintiff in that case brought an account stated cause of action. It didn't bring a claim under the contract, and it brought it based on the billing statements that it had been rendering to the defendant in that case. And the defendant said, wait a minute, court, you can't decide this because we have a contract and the contract controls this. And the court said, no, I've got these billing statements. I see that
I don't understand how, I do not understand how that is responsive to the question I asked you about the specific provision in these agreements, of which essentially provides, both of them provide that you can get attorney's fees. That is, the creditor can get attorney's fees if you have to get a lawyer who's not your salaried employee to collect the account.
Exactly, Your Honor. And that was my second.
Well, when you say exactly, I don't know what you mean. I mean, how does that not cover the action that was taken here based on account stated? Whatever mechanism you choose to collect the account, you would have to concede that the account stated action in this context is an action that is collecting the account.
Your Honor, the exact contract provision was at issue in Talinsky, and Talinsky involved two different documents.
I'm not asking about those cases. I'm asking about the text of these agreements.
Exactly.
And just the plain language of those agreements and what it means, and how anyone could look at that and come to the conclusion that it's not covered. Now, again, I'm sorry if I'm missing something, but help me understand.
Your Honor, exactly. Portfolio had a choice. Okay, it had a choice to bring an action upon the contract or upon the billing statements under account stated.
Well, you can choose your cause of action, but you can't choose your attorney's fee provision, and you can't choose the terms of the statute. And when I realize there's different things here, but I cannot understand how this is not covered. But I will cease.
Well, Justice Kennedy, again, and if I may finish. Portfolio had a choice whether to bring it on the contract or the billing statements. The billing statements contain no such fee provision. It contains no such language, okay? And this is really the same as the Talinsky case. In the Talinsky case, there were two separate documents. One document had a fee entitlement, and it had the same exact language here. If we hire an attorney to collect on your account, that was in the Talinsky case. That language appeared in the RISC, which is the retail installment sales contract. The other contract, the ROC, which is the retail order contract, did not contain any such language. And the car dealership had a choice which document to plead. And it pled the ROC, which did not include that. Now, under the debtor's reasoning here, Talinsky would have been decided differently because there were two documents, and there was an underlying contract between the parties to enforce the agreement that allowed for fees. And under their reasoning, just because that exists, then you get any fees for any action with respect to the contract.
There's only one contract here, though, correct?
There is one. Well, there's two different causes of action available here.
I understand that, but there's one contract.
There is the contract that was the credit card contract, which is completely irrelevant to this case. And there is the account stated cause of action, which is based upon the billing statements. And Your Honors, there's all sorts of reasons why a plaintiff might want to bring a common law cause of action as opposed to an action under the contract, and that's their choice.
I'm sorry, counsel, I'm sorry for interrupting you, but could you focus on the second part of the sentence in the statute and explain sort of your best argument for why this is not an action with respect to the contract? Because regardless of what we think about the first clause, if it's not an action with respect to the contract, then it doesn't matter.
Certainly, Your Honors. And if you look at the cases, beginning with Caulfield, that the debtors have stated and relied on with respect to the contract, all of those cases, every single one of them requires the court to look at the contract to figure out the case. Caulfield was a purchase of real property, and the action in that case was fraudulent misrepresentation based upon the condition of the property, where the sewer was, and defects in the property. Had there never been a purchase, had they never had a contract to purchase the real property, it wouldn't matter. Any misrepresentations wouldn't have mattered.
So you can see, though, I'm sorry to interrupt you. I'm kind of surprised by your answer, though. I mean, I thought what I thought you would say is that with respect to the contract is a simple are you seeking to enforce the contract or not? I mean, why would you want to go down the path of having to look at non-contract causes of action and then do some sort of fact-based inquiry as to whether there's a sufficient connection between the non-contract action and the contract?
Well, I think, Your Honor, as we argued in our brief, we think this 57105 only applies to contract cases, and this is not a contract case. And I think if you read 57105 and ignore the first part to enforce a contract, there's no reason why the legislature would have put that in there to begin with. They could have stopped that by saying if a contract contains a provision allowing attorney's fees, would he or she is required to take any action? To enforce a contract isn't even relevant here. But if you're looking at the second part, which I thought was the question you asked me, what are these cases with respect to the contract? If you look at all of these cases where it was found to be with respect to the contract, it requires the court to look at the contract to figure it out. And that is Caulfield. As opposed
to the cause of action. So you're conceding that we look at the contract itself rather than looking at what the cause of action is that's the subject of the lawsuit? Well,
no, Your Honor, I think that's all the same answer. An account stated cause of action is an independent cause of action that never has to rely on the contract. It's based upon these billing statements. It's based upon the history of the two parties having a business relationship. It's based upon the implied promise to pay based on these billing statements that have not been objected to. It's a lump sum. It doesn't matter. The specific transactions don't have to be itemized. It's just based on that cause of action. So account stated doesn't have to. And so Caulfield is not an account stated case. Caulfield had a bilateral fee provision. And the question there was whether this fraudulent misrepresentation arose or was with respect to arose out of the contract. It wasn't even a 57105 case.
Mr. DeWolf, isn't the creditor's claim necessarily with respect to the contract because of its including interest and late fees?
No, Your Honor. In the account stated cause of action, no itemization is required. When it purchases these accounts from the bank, it takes the final amount, and that's the amount due. And if you look at the record, you'll see, PRA takes this amount and it sends these notices to the debtors, and it says, here's the amount you owe. If you don't think you owe it, if you think there's been a mistake, which is how you overcome an account stated, please let me know. And we'll settle this. PRA doesn't charge any fees or interest based upon the contract. It actually offers to allow the debtor to settle for less money.
But there would be no amounts due but for the contract, particularly the very high interest rates and late fees.
Well, no, that's not true, Your Honor. The contract and the interest that starts under the contract is irrelevant to the final amount that's due in account stated. And that's been the case. That's the Farley case. That's the Burke case. That's the Whittington case that we've cited in our brief. The specific items that make up the account, this court said in Whittington, the original cause of the debt is not important. This is based on a final amount based on these statements that have not been objected to. So that part is just not irrelevant. So,
counsel, could you pursue an account stated action, not seek fees, prevail, and then rely on this collection cost provision in the contract to then tell the debtor, hey, by the way, I prevailed in this suit and it cost me such and such. Now I'm going to charge you for the amount of my attorney's fees?
Absolutely not, Your Honor. And that's exactly what happened in this case. That's what the debtors did. They came into court, they answered the complaint. They said, we don't have any accounts. We don't have a credit card. We don't know these people. They categorically denied all the allegations in the complaint, and then came along at the last minute, which, defies any logic, and said, well, now that I've denied that I even have a contract or any account with you, I can get fees under this contract. That is simply not the case. And, you know, counsel said this is some sort of litigation strategy and it's some sort of tactic that PRA uses to avoid fees. Well, of course it is. You know, look at what happened in this case. PRA brought an account stated cause of action, a common law cause of action, which has no fee entitlement, and it comes into court on an $800 claim, Your Honors, and its business records custodian is unable to validate these records to the satisfaction of the court, and then PRA is subject to attorney's fees for a cause of action it never pled. Not just attorney's fees, Your Honors, $50,000 in attorney's fees for an $800 charge. That is for a cause of action that was never brought under the contract in the first place. So no, PRA brings these claims and it gives up its right to get fees.
If I could interrupt you, I mean, that's a separate theory, isn't it? I mean, and potentially a valid one. I haven't looked at that line of cases, but if you deny the existence of a contract and win, I mean, if it's not established that there was a contract as a matter of fact, I thought there was a whole separate line of cases that said that you couldn't get fees after denying the contract. But that's not an issue in this case as it's been framed for us. Would you agree?
Your Honor, there is, a contract in this case between the parties, but the contract is not part of the cause of action, so it doesn't matter.
I mean, I understand all that.
Right.
Different question. Well, and let me ask you something different. We're running out of time, but the first part of the statute talks about if a party takes any action to enforce the contract. And the same question I asked your opponent, but you seem to be using the word action to mean cause of action. Am I right about that?
That the account stated is a separate and distinct cause of action for a breach of contract or an action to enforce the contract. Yes, Your Honor.
Wouldn't you agree that in context, if you use the phrase take any action, that could not be talking about action, a cause of action? In other words, a synonym for the word as it's in the sentence would be take any measure or take any steps. Wouldn't that be the way action is used in that phrase?
Well, yeah, I mean, I think I have to agree with you. To take any action to enforce a contract would not be limited to strictly breach of contract. It would be to take any action to enforce a contract.
Right.
But my point is that the account stated is not any action to enforce the contract. It's not.
But you're telling me that when you file to collect money that includes payments that are due pursuant to a contract, interest, other fees that are due pursuant to a contract, in the vernacular, aren't you taking steps to enforce the contract no matter what cause of action you use?
No, Your Honor. No, Your Honor. PRA purchases these accounts. And when it purchases the accounts, when those accounts come into its possession, it brings it an account stated claim for the total amount due. It doesn't matter what payments were made. It doesn't matter what part of this is interest. It doesn't matter what part of it is fees. The original cause of the debt is irrelevant to this cause of action. It's a common law cause, which can just be brought on the lump sum. So
you're now in overtime. If you'd sum up in about 15 seconds.
Thank you, Your Honors. And we would ask this court approve the decision of the first DCA in Ham and disapprove the second district's opinion in Bushnell. The whole otherwise gives greater rights to the other party. It unlevels the playing field, Your Honor, and it offends the well-settled principle that a plaintiff gets to choose its cause of action. Thank you very much.
Thank you. Counsel?
May it please the court. I realize that this case has broad statewide significance. There are literally hundreds of county and circuit court rulings that preceded Ham and Bushnell around the state, probably 50-50 on which way they were decided. But that said, I'm concerned about my case, despite the broad implications. And in my case, one thing I want to emphasize The court suggests, well, isn't there only, I think it was Justice Moniz, isn't there only one agreement? And yes, there is only one agreement, and that's the credit card contract. Portfolio failed to prove there was an account stated agreement. You know, counsel keeps talking about the agreement. There was no agreement. They failed. So the only contract we have in this case is the credit card contract. The second point I want to make is about the interest charges. First of all, those billing statements were not sent by Portfolio. They were sent by the bank. And as assignee, Portfolio has no greater rights than the bank has. So the bank sent statements with interest rates almost 30%. Now, there's a statute, I believe, and I think the number is 687-01, that says you have to apply the statutory interest rate unless you have a special contract. Well, in this case, obviously 29.99% is not the statutory interest rate. There must be a special contract. Well, of course there is. It's the contract between Mr. Ham and the bank that provides that interest rate. The final point I would like to make is Portfolio kind of a woe is me, look what happened in this case. We tried to litigate account stated and we ended up owing $50,000 in attorney's fees. Well, why do they owe so much money is because they sued my clients and they couldn't prove their case. They brought a witness to court from wherever with the documents, and she clearly could not get around the hearsay rule. She had no personal knowledge of where the documents came. So Portfolio has nobody to blame but itself. So with that said,
Mr. Rosenbloum, I'm sorry to interrupt you. Could I just ask, is there any evidence in the record about whether the individual charges referenced the cardholder agreement, that is the receipts? Is that in the record at all?
I'm going to be honest with you. I don't think there is a transcript in the record of the original trial where all these documents were proffered. I know that the billing statements were proffered. I doubt very seriously if there was any reference to the contract until after the county court entered judgment in favor of the defendants. So with that said, I would respectfully urge the court to quash the Ham case and approve Bushnell. Thank you very much.
For your arguments. And the court will now turn to the next case on our docket.